When can multiple employers be held jointly liable for overtime and minimum wage violation? The answer is found in today's new set of rules from the Department of Labor's Wage and Hour Division. This set of rules will be published tomorrow, April 23rd, in the Federal Registry, and it'll be open for public comments for 60 days, and then it'll be finalized. What this does is that it looks at a bunch of rules by different federal circuit splits on when a company can be jointly liable with another company, the employee or of a particular set of employees, for FLSA violation, overtime and minimum wage violations. And they came up with a couple things. Okay, so first of all, you have a couple of factors. One, whether or not an employer can hire or fire. Number two is whether or not the employer can supervise and control the work schedule of the work conditions of the employee to a substantial degree. And that's up for interpretation by different courts, and different courts in different circuits have different ideas of what substantial means. And the third factor is whether or not the employer can determine the rate of pay and the method of payment. Last is whether or not the employer maintains employee records. And it's really clear, though, from both federal opinions and this particular set of rules from the DOL that none of these four factors are dispositive, meaning none of these factors determines the finding of joint employee liability by itself, but the more the better. In application, it's up to the courts to interpret which one's more important. Sometimes a court may find one item and they say that's enough. Sometimes the court will say, no, you need all four factors. But the text of the rule is no one of these four factors are more important than the others. Now, there's a set of prior rules that is no longer being followed. So the DOL is kind of disclaiming this factor, and that is the right of control. It used to be law that if an employer, a joint employer, has a right to control the employee, then that right of control is determinative. It establishes that they're jointly liable because they're a joint employer of that employee. But now it's not as important. So the key thing is, though, that it's the difference between does the partner business have the right to control contractually, but they don't exercise it on a regular basis, then it doesn't matter. So there's still a right of control element there that the courts look at, but it's whether or not the frequency of that exercise. And you can see that applied in franchise agreement where the franchise company will have sets of rules and procedures for the franchisees, but they write the rules, but they don't enforce the rule. They have a right to come in and say, you're not conforming to our standards, we're going to fire you, but not the same thing. So that's just an example. So oftentimes when different companies go into partnership together, they'll give one company the right to terminate or right to control certain employees, but that company, that partner may not exercise it on a regular basis as part of their business operation. And so the DOL is saying that if you don't exercise that right of control on a regular basis, then it doesn't mean that you're a joint employer. It doesn't weigh against you. So take a look at it because it has a bunch of other changes. And I'm going to make one last comment, and that is it's rolling back a lot of the rules implemented by the DOL during the Biden administration, and it's recognizing and reviving some of the laws that were in place prior to Trump coming in. And so in the grand scheme of things, these are existing set of rules that lawyers are following anyways, but now it has the weight of the DOL coming in and saying, hey, right of control, not so important. And we like the four-factor test, so it's encouraging the courts to follow the four-factor test. Okay, back to work.